Well, thank you so much. Who knew I'd be a celebrity over gender? I always wanted to be famous. I'm not sure that this was what I was looking for. But I want to first say thank you to Genspect for holding this all-important event, which is more crucial as we mourn the loss of Charlie Kirk, who took the concept of having open discussions to a new level. When thinking about the legal landscape of transgenderism, a quote from one of my favorite childhood authors, Charles Dickens, comes to mind. It was the best of times, it was the worst of times. It was the age of wisdom, it was the age of foolishness. It was the spring of hope, it was the winter of despair. So like the tale of two cities, we're having some incredible wins and some terrible losses in the courts. But I do not believe that the losses should be seen as true losses because the mainstream media is forced into covering these cases, which educates more parents, politicians, and the judiciary and the medical community to the destructive nature of the transgender movement. So let's talk good news, bad news. As Josh discussed, the case of U.S. versus scrutiny was an incredible win for the 27 states that have some sort of ban for sex-rejecting interventions on minors. Well, it does not directly help the blue states or stop these horrifying so-called treatments for adults, which must happen. The lengthy opinion was chock full of goodies, as was the oral argument. Two highlights from the oral arguments were when Justice Thomas was querying the Solicitor General about whether there are any differences between the sexes. And she begrudgingly had to answer yes. So even the Biden administration had to admit that trans women are not women. The second, as Josh talked about, was the just delicious response from Chase Strangio of the ACLU when she contradicted what her co-counsel, the solicitor, had been arguing. Strangio admitted that suicides of so-called transgender kids were thankfully rare. In an instant, the suicide argument was practically obliterated. The majority opinion itself was fantastic, but what I found most intriguing were the concurring opinions. So Justice Coney Barrett questioned the narrative of a trans-identified person as being a suspect or a protected class, noting that identifying as transgender is not immutable or a stable identity and should not be added to the extremely narrow classifications of individuals who are afforded the highest legal protections, and that's race, lineage, and national origin. Justice Thomas, okay, I think I got a crush on Justice Thomas just from his concurrence, was just pure gold. And he made three major points. As Josh pointed out, the most important, I think, was that he called out the so-called experts. He made it clear that the courts do not need to follow the AAP, the APA, the AMA, and all the other three-letter acronyms because they may not be the so-called experts. And he also took the time to kindly eviscerate WPATH. He also described all the available interventions, which is really important because I don't think the public actually understands what it means to so-called transition. He used the word phalloplasty and laid bare all the all the harmful effects of sex-rejecting interventions, and then described how our European counterparts have curtailed these treatments. And third, he raised the issue of regret and detransitioners. He specifically referenced their amicus brief. So this should remind us how important these brave young adults are in our quest to destroy gender ideology. So thank you, detransitioners. Then we had the Supreme Court opinion of Mahmoud versus Taylor, another great win, but this victory is limited to those families with sincerely held religious beliefs. I advise all parents to find God. Mahmoud involved the question of whether religious parents have the right to opt their children out of LGBTQ story time, which had lesson plans that would chastise the students if they did not agree to accept the character's identity, choice, or ability to change sex. Initially, the school district had an opt-out. Well, 1,000 parents opted out, including non-religious families. This is a great fact for the Supreme Court to also know and for the public to know. That triggered the district to take away the option, of course. They couldn't have the option anymore, and they claimed that those books are needed to create a safe and conducive environment for learning. Talk about a four-letter word. Safe is a really bad four-letter word. It has no meaning anymore. So the Supreme Court found against the school district, holding that the schools cannot have a curriculum that substantially interferes with the religious development of a child or poses a real threat of undermining the religious beliefs and practices the parents wish to instill in the child, which is a fact-intensive inquiry. So this opinion went farther than just requiring opt-outs for LGBTQ story time, but that fact-intensive inquiry leaves open a huge gap for schools to continue to find creative ways to try to inculcate students with lessons about transgenderism. Some school districts, like in California, my state, are interpreting the case narrowly, setting a minimum of opt-outs just for elementary school parents. That leaves open the high schoolers who will continue to be taught about trans regardless of their religiosity. I believe this is an incorrect interpretation of Mahmoud, since the decision relied heavily on a case about Amish parents who were allowed to pull or avoid sending their children to high school because of their religious beliefs. There's a current case in California in which a school had fifth graders read LGBTQ books to kindergarten, first, second graders. It is a new low for California, kids being required to indoctrinate other kids. That case is currently on appeal, so we will see next year how Mahmoud will be applied in California. Now, the Seattle School District has taken the bold step of thumbing its nose to the Supreme Court. On its website, as of last week, it states that no student can opt out of LGBTQ story time, not even kindergartners. In 10 days, for all you therapists out here, big day, in 10 days, the Supreme Court will hear oral argument in Childs versus Taylor, which will decide if states' anti-conversion therapy laws violate freedom of speech. The state laws at issue were designed to strike fear in the mental health providers who fail to blindly affirm a child's sex-rejecting identity. Only 18 states don't have some form of prohibition. Well, the anti-conversion therapy laws do not prescribe exploratory therapy, which all genuine professionals should be employing. The purpose of the law worked. And as we all know, it's extremely difficult to find a mental health provider who does not believe that they are required to affirm a child's identity or risk losing their license. I am 100% confident that the Supreme Court will rule in our favor in this case, and this ruling will have a countrywide effect. But it will not stop the affirming model in its tracks. That's going to take, unfortunately, many more years. Turning to the sports, there are two cases right now before the Supreme Court, Little versus Hecox and West Virginia versus BPJ. Now that Hecox case or Hecox case challenged an Ohio law that bans males from female sports. What is extremely interesting is our dear friend Chase Strangio of the ACLU recently asked that the case be dismissed before oral argument. And that is because I believe Mr. Hecox claims that he doesn't want to play women's sports anymore. He wants to concentrate on his studies. And he also wants to protect his mental health. Well, that's ironic, because the males who want to play in women's sports always argue that being able to play sports based on gender identity is crucial for their mental health. So it's my opinion that the 24-year-old Hecox, who did not undergo any sex-rejecting interventions as a child, is simply not a sympathetic enough party, and Strangio wants to avoid another colossal, embarrassing defeat. Luckily, the Supreme Court can force Hecox to proceed with his case, and I expect it to do so. The BPJ case involves a male who began sex-rejecting interventions when he was about 11, and so therefore he should be sympathetic, but his behavior in the female locker rooms will likely erase any of that sympathy he would have garnered. The BPJ case involves both a Title IX claim and an equal protection claim. Now, Title IX deals with funding from the federal government, but the equal protection claim is a really important one because with an equal protection claim, it deals with equal treatment under the law. And this will require the court to determine the hierarchy between the incoherent concept of gender identity and sex, because sex-based rights cannot exist if gender identity is also afforded the same protections. This case will likely, again, be decided in our favor, because we know from the Scrutiny case that many of the justices are just not buying the argument that an internal sense of self trumps actual sex. And there are a number of significant sports cases going on around the country. We already talked about the Riley Gaines case, which is continuing, and that means discovery is going to open. And discovery is so worthwhile because this is how we learn about the connections between the nonprofits, the trans activists, and government actors, how they have been colluding to allow males into our female sports and spaces. The really great thing about the sports cases, too, is that we have the might of the federal government behind us. The Department of Education, Office of Civil Rights, and Department of Justice have all filed suits against universities and schools. There are also lawsuits directly challenging liberal state laws that require sports and facilities to be based on gender identity. We have 2 of those going on in California right now. Child and Protective Rights Campaign and I just filed a lawsuit last week on behalf of Coach Beatty Smooth, who was the coach for the San Jose State University. She was the coach who then called out that there was a male playing on the female team, and then she was terminated. So we filed that last week. It's so shameful and embarrassing for our country that lawsuits are needed to protect sex-based rights. But that's where we find ourselves. All of this should be embarrassing to America and to all the industrial countries that are doing this. But I want to move back to the school cases, because for the most part, teachers and professors are winning or receiving respectable settlements if they raise a religious claim for refusing to lie to parents about their students' adoption of sex-rejecting identities, or when they refuse to use a different name or pronoun. Right now, I'm following a case by John Klug in Indiana. He is a high school teacher who was religious. He's religious, and he called all of his students by their last name. He did this to avoid using male name and pronouns for two females who wanted to be treated as boys. Well, these girls claimed to feel bad. They were sad. And because they were sad, they got the teacher fired. One of the girls said, and I quote, "I truly believe that if everyone in my life had refused, like Mr. Klug, to use my corrected name, I would not be here today." This is so emblematic of the learned fragility of sex-rejecting youth. This poor child and all the other individuals who believe that their lives hang in the balance over the ability to control someone's language and thoughts is extremely disturbing. Well, so we have our secret social transition cases. There are about 31 across the country at the moment, and they have yet to achieve widespread success, but that victory is on the horizon. The basis for all of these secret social transition policies, and I'm sure you all know what they are, right? Name and pronoun of the child is changed at school, they're treated as a different sex, and parents are kept in the dark. The basis for all of these, which still exist almost in every state, in almost every public school, is the felonious presumption that parents who refuse to believe that their child has a defective body are abusive. That's the basis for all of these. Every single secrecy policy has as its justification that schools need to be a safe space away from parents. For example, in a Florida school district, the secret policy instructed school officials not to tell the parents about their child's adoption of a trans identity because, and I quote, "Parents can be very dangerous. Outing students can literally make them homeless." This was the basis to lie to parents. In the Foote case, the appellate court said, keeping parents in the dark creates a space for students to express their identity without worrying about parental backlash. That is our appellate court. But this type of reasoning flips the law on its head. First, I have likely spoken to or interacted with more than 500 parents with kids adopting sex-rejecting identities, and not a single one have harmed their children physically or emotionally, or have abandoned their child. They all have leaned in closer. 2, the Supreme Court almost 50 years ago ruled that there is a presumption that parents have their children's best interest at heart. The Supreme Court said that the notion that governmental power should supersede parental authority in all cases because some parents abuse or neglect children is repugnant to the American tradition. 3rd, schools are not empowered as courts. They cannot adjudicate a parent as abusive. Parents have a right to due process through the courts. They have a right to defend themselves. These parents don't even know that the school has dubbed them abusive. It's just an automatic, done in stealth, done in secret. But I predict that in 2026, the Supreme Court will rule that parents have the fundamental right to raise their child as his or her sex, the most essential aspect of being a human. I will close out by briefly talking about the family law and dependency cases. The win-loss, sorry, I'm getting chills here because I hate talking about this. The win-loss ratio for parents who want to safeguard their children from social or medical interventions is devastatingly poor. And the Supreme Court provides no viable path unless we change current law. But I'm going to tell you this. There is some good news. A team of very smart attorneys and I have written a proposed executive order on this very issue. It was received. I know it was received by the administration. I got confirmation of that within 24 hours of me submitting it. That's not a promise that we'll get it signed, but it should show you how invested this administration is in really destroying gender ideology and it's all of its forms in every place where it lives. We also wrote companion federal law that should stop the taking of children from parents who just want to raise their child as their sex. And we are using every one of our connections in DC to make this happen. And I do believe that it will occur or I will die trying. Do questions? 2 questions.
Stand up, please.
I have a question about divorce cases and how sometimes one parent will want to transition, the other one resists it. Like, tell me what's going on with those cases. Thank you.
You know, I would venture a guess it's about 90% of those custody decisions go to the parent who is willing to affirm the child's gender identity. And this is because for the last about 10, 15 years, it might even be 20, the gender ideologues have been training judges across the country. And they have been training the minors' counsel or guardian ad litems. They have been training the social workers who work with the courts to find parents who believe in the reality of sex to be emotionally abusive. And the problem with these cases too, these divorce cases, are they're really difficult to appeal. And so you don't get, and you're not in federal court, so you can't bring these cases forward. And a lot of these parents also go bankrupt fighting for custody of their kids. So it's a really sad state of affairs. But we have a fix. The federal law that we're proposing will hopefully stop it.
Hi.
Hi.
So I have a question about the conversion therapy case that's going to the Supreme Court. Is there any concern that if they win, and I don't know how the brief is worded, but that it would, number one, give cover to gender-affirming therapists because they could just say, it's my freedom of speech to practice this way. Number two, are they parsing out the difference between gender identity and homosexual conversion therapy practices? Because I would definitely not like to see that re-legalized.
Well, that is a very good question, and it's a very difficult one, and this is why the gender mafia attached it to the sexual orientation piece, because they know detaching it is impossible. But I think the Supreme Court has to either decide that therapy is a First Amendment right or not. And so, unfortunately, the sexual orientation is going to go right along with the gender identity piece. And look, the therapists, the affirming therapists already are doing what they're doing. And we can't give up real First Amendment rights, because First Amendment rights are first for a reason. They are vital for the United States. And so we have to be very careful on kind of trying to parse out, carve out exclusions for it. So yes, I understand your fear on that, and certainly when we wrote our brief, and I know a lot of the feminist groups wrote briefs, we tried to enlighten the Supreme Court that there's a big difference between the LGB and everything that follows after it. Thank you.